Michael Popok, Legal AF. Time to dive into the nitty-gritty of the Appellate Division First Department in New York, who heard oral argument today for Donald Trump to try to overturn his $465 million fraud judgment of disgorgement brought by Judge Engoron in February. It was a little bit rocky for the lawyers for the New York Attorney General. It doesn't mean, in my opinion, that ultimately the entirety of the $465 million is going to be overturned. But I think it's going to take a hit, and they could strike $50 or $100 million over it. Let me give you the short answer up front, and then I'll tie it together in the hot take. I don't think they're going to vacate or overturn the ruling. I don't think they're going to throw out the entirety of the $465 million judgment, running with $100,000 of interest every day against Donald Trump. This is the same panel, just to put it into some kind of context, who about 6 months ago told Donald Trump he only had to post a $175 million bond to stop the enforcement of the judgment, not the full $465, and they would deal with the rest of it on appeal. At the time, I thought it didn't signal that they were going to drop the judgment down to $175, but rather they knew that Donald Trump had a lot of assets and the Attorney General had a lot of power, and that a financial monitor was in place for the last 3 years overseeing all of Donald Trump's assets, so they weren't concerned. But it did signal that they thought that $175 million may be at least the bottom line where they come. I think they still end up with a judgment of $300 to $400 million. And let me tell you, as a practitioner in the Appellate Division First Department for almost all of my career, very few judgments and verdicts, especially of this size, by a trial judge, end up unscathed. I can't think of one where the appellate division, the 5 justices that are assigned to on a panel for a certain case, don't decide to take out a blue pencil and do their own math and start reducing it. And we just expect it. The lawyers that practice regularly at the Appellate Division First Department know that they can't spend the money from their judgment at the trial level until they get through the Appellate Division First Department that sits in Manhattan. So I think that's going to happen here. There's going to be some haircut, if you will. I just don't think they throw out the entire thing. It's going to be somewhere between, I don't know, 175 and 350. That's millions of dollars for Donald Trump's persistent fraud. Recall that after a 6-week trial, Donald Trump, Don Jr., Eric, everybody but Ivanka, and the Trump Organization was found to have committed persistent fraud, as that term is used in the state of New York, under an executive law that empowers the New York Attorney General to be the watchdog or the sheriff of Wall Street and financial markets. It doesn't matter that the parties are sophisticated. In fact, the more sophisticated the parties on both sides, sometimes the bigger the fraud that has to be regulated by the power of the Attorney General. So you go to 63-12 in the code book, and there it is. It's been sitting on the books for a long, long time, since the 1950s and 60s. And Donald Trump hates it. His major argument is, there's no victims. All the banks love me. All the insurance companies love me. Sure, I lied to them about my personal financial statements. Sure, I increased the value of all my assets just so that my personal financial statement balance sheet would be better, so I could borrow more money, I could take out more insurance, I could get approved for more loans. But so what? Who was harmed? I don't know, you, me, everybody else that's standing in line at the bank to get our loan at our rate. And that is the major problem. So we got a 5-judge panel today. I listened to that oral argument. Let me tell you about the 5 justices of the Appellate Division First Department, which is the first level appellate court in New York. We've got 2 levels here. Top court in New York is called, just to be confusing, the Court of Appeals. So here we're at that level. I know this first department well. I got sworn in there in 1992. I love the ceremonial courtroom. I've argued there many times. Here's the 5 justices assigned to the case. The chief justice, or the presiding justice, is Justice Renwick. We also have Justice Moulton, Higgett, Rosado, and Friedman. Friedman is the wild card. Friedman is the judge who on more than one occasion gave Donald Trump not 1, but 2 stays of decisions by Judge Engoron pending the full panel. Now, when the full panel got together, they overturned Judge Friedman, but we always suspected that he was a closet MAGA or closet Trumper. And it showed its color. He showed his colors today during the oral argument that lasted about an hour. Judge Renwick sits in the middle. I'm gonna play a clip in a minute. And then you got Judge Moulton. The intellectual fulcrum on this panel today, the heft, the weight. The gravitas is really Renwick, who's the presiding judge. She sits in the middle, and Judge Moulton. And you'll see the back and forth, the volleying back and forth between them and the lawyers. And then you got Friedman on the outer boundaries there, on the periphery, who's obviously throwing softball questions to help Donald Trump. Let me set the stage further about who's the cast of characters here. Those are the 5 justices. They were the same ones that had set the $175 million bond. They kept the financial monitor, former federal judge Barbara Jones, in place, subject to this hearing that we're doing today. We should receive a decision in about 4, 6, 8 weeks. Certainly, I believe it'll come before the election. I think they'll think it's important that it come out before the election so the voters can know what they're voting for or what they're voting on. They were not, however, the appellate panel that did the summary judgment and prior orders in the case. That's a different randomly selected five justice panel. I just wanted to have you have that for context. For Donald Trump, the lawyer he brought in seems to be the appellate lawyer he has the most confidence in, and it's John Sauer. John Sauer, he of the gravelly voice. It always sounds like he gargled an entire pot of broken glass and bourbon before he got up and argues. But give credit where credit is due. He was successful for Trump before the United States Supreme Court in the Colorado insurrection decision that kept Donald Trump on the ballot. And he was successful before the United States Supreme Court for Donald Trump in the immunity decision that came out in July. Same advocate. Now, the difference here is we're now in the Byzantine world of New York practice, which I, having practiced here for 33 years, I'll tell you, there's some lawyers that just know the code and the civil procedure law and rules, CPLR, like the back of their hands. It's a very unique place. It's like no other. If you've never practiced here, it's difficult. John Sauer did okay. You know, he thinks he's getting paid by the word, so he loves to shove, where 100 words will do, for John Sauer, 5,000 will do better. And so you have this kind of run-on sentence that goes on for his entire 40, 50 minutes up there. I can tell you from talking to judges and justices in New York, including today, and former judges, about what they observed. They're like, that kind of advocate doesn't help us. We just want him to stop talking so that we can get to the record, the documents, the information, and the briefs and make our decision. So I'm not sure he was that effective, knowing that he's not really a New York lawyer. It could be seen as what we call a carpetbagger. They brought in, for a little bit of home cooking, a guy who just hangs around the Appellate Division First Department, and very, very well-known guy, Brian Isaac. Every justice knows Brian Isaac. He's arguing cases there 2 and 3 times a week. He's been doing it for 30 years. He's very much a New Yorker. I mean that as a compliment. And he was there for Donald Trump. And his job was to spout off verbatim from the top of his head every section of the civil procedure law book and rule book and cases, and then stroke them. He did a lot of ego stroking. You are the finest justices. There's a reason you're the finest justices. I was like, when is he going to stop jerking their chain and start making an argument? But he was just there so that John Sauer wasn't sort of home cooked. That he didn't have a home court advantage against the New York Attorney General. The lawyer that argued for the New York Attorney General, first time we've seen her, is Judith Vale. She argues a lot for the New York Attorney General as one of their appellate experts. When I saw the panel, I wasn't worried about Friedman because you have to get a 3-2, 4-1 majority wins. And when I saw Moulton, who's very good in commercial matters, very smart, doesn't say a lot, but when he does, it matters. Renwick, I liked a lot. Higgett, I liked a lot. Rosado's relatively new. Friedman, I was like, oh, here we go. Traditional bed sheets, they can harbor more bacteria than a toilet seat. It can lead to acne, allergies, and stuffy noses, and it's just gross. Miracle Made offers a whole line of self-cleaning, antibacterial bedding, such as sheets, pillowcases, and comforters that prevent up to 99.7% of bacteria growth and require up to 3 times less laundry. Using silver-infused fabrics inspired by NASA, Miracle Made sheets are thermoregulating and designed to keep you at the perfect temperature all night long, no matter the weather. So you get better sleep every night. Miracle sheets are luxuriously comfortable without the high price tag of other luxury brands and feel as nice, if not nicer, than sheets used by some five-star hotels. Stop sleeping on bacteria. Bacteria can clog your pores, causing breakouts and acne. Sleep clean with Miracle. These sheets are infused with silver that prevent up to 99.7% of bacterial growth, leaving them to stay cleaner and fresh 3 times longer than other sheets. No more gross odors. Go to trymiracle.com/legalaf to try Miracle Made sheets today. And whether you're buying them for yourself or as a gift for a loved one, if you order today, you can save over 40%. And if you use our promo, LegalAF at checkout, you'll get 3 free towels and save an extra 20%. Miracle is so confident in their product, it's backed with a 30-day money-back guarantee. So if you aren't 100% satisfied, you'll get a full refund. Upgrade your sleep with Miracle Made. Go to trymiracle.com/legalaf and use the code LegalAF to claim your free 3-piece towel set and save over 40% off. Again, that's trymiracle.com/legalaf to treat yourself. Thank you, Miracle Made, for sponsoring this episode. And there were some things that happened during the oral argument that gave me a little bit of a concern. There was a moment where Justice Moulton, who I kind of counted on to preserve most of this size judgment, questioned the advocate, Judith Vale, for the New York Attorney General and used an interesting choice of words that gave me a little bit of a pause. Let's play that clip.
The immense penalty in this case is troubling. So how do you tether the amount that was assessed by Supreme Court to the harm that was caused here, where the parties left these transactions happy about how things went down?
Well, disgorgement, Your Honor, looks at taking the gain away from the wrongdoer. And although this is a large number, it's a large number for a couple reasons. One, because there was a lot of fraud. This went on, and illegality. It went on for 7 years during the statute of limitations period. Another reason is because the guarantee and the financial statements each year worked to get enormously favorable interest rate savings to the defendants. It was a difference of approximately 4 to 8 percentage points, obviously varied by year. That is an enormous benefit that they got from the misconduct. And it is not an excuse to say, well, our fraud was really successful, so we should get some of the money.
Was there double counting in the damages assessed for the old post office and the Ferry Point?
No, there was not double counting, Your Honor. Two points on this. First of all, the interest rate savings and the sale profits are separate pots of money. The defendants got the interest rate savings off the top. There's no suggestion that they invested that savings into the OPO. They were using the loan, and so they got the interest rate off the top. That was the savings that they got. Each year within the statute of limitations, they were getting a savings by doing the fraud over and over again and the illegality. And then the sale profits are separate. And the sale profits, it's not the proceeds. The proceeds of the loan of the sale were around $370 million. The trial court took out the repayment of the Deutsche Bank loan, and I think defendants themselves had taken out already the taxes. And Mr. Trump testified that the number for him, around $126 million in profits, was his.
All right. So when Judge Moulton, who's probably the one that could well end up writing the majority decision, says that he finds the size of the award troubling as opposed to, it's a big award, let's talk about it, that gives me a little bit of concern. And that may already be signaling that that number is going to come down by some large tens to hundreds of millions of dollars. Even if it dropped to 250, that's a lot of money for Donald Trump to come up with. But, he's trying to, he's burning through $100,000 a month just for interest on this thing. And that's why he's fighting so hard to get the judgment removed. So I've been involved as an appellate advocate. Sometimes you can tell what they're thinking. Sometimes you get a hot bench, you walk out, you reach behind you, you make sure your rear end is still there, and you say, wow, I'm going to lose this. And you get home, and a month later you get the decision, and you've won. And sometimes you think, I just had a great day in court. Things went well for me. I answered all the questions. They seemed to be with me. Hooray. And then you get the order and it's like, I lost. So it happens. Sometimes it's hard to tell, especially when they're playing their cards close to the vest, as to what's going to happen. But if I were like guessing right now, and I'm giving you my best professional guess here on Legal AF, I would think that Moulton is going to end up writing it. Renwick is going to sign it to him. He's going to get his 3 votes, maybe 4 votes, but the decision is going to lower the amount of the judgment from Judge Angoran from the 465, maybe down to 325, 275, 250, something like that. I don't think it goes below the 175 where they've already signaled. But it'll still be a gigantic number, still the findings of persistent fraud against Donald Trump, coming on the heels of a 34 felony count conviction in another court that also reports up to the Appellate Division First Department in a criminal case against Donald Trump with Judge Merchan. Different case, same Appellate Division. And I think that's where we're going to kind of end up. We'll follow it all. And you know where we follow it all. We follow it all on Legal AF. Find out what 40 million people a month already know. That Legal AF is the home of the most unique, I think, and interesting and informative analysis and commentary at the intersection of law and politics out there anywhere on YouTube. I defy you to find better. You can get us in multiple ways, all related to the MeidasTouch Network. You can get us on our podcast. We record the live version of it on YouTube here on the MeidasTouch Network, Wednesdays and Saturdays, 8 p.m. Eastern Time. You can get my hot takes like right here, like I do right here on the MeidasTouch Network. But now, in collaboration with the MeidasTouch Network, we've formed a new channel. Got so excited I got tongue-tied. Legal AF MTN, Legal AF MeidasTouch Network, on this YouTube channel. And help us get to 100,000 subscribers in our first 10 days. That's all we are. We're 10 days old. Popok had a second baby 3 months in, as people know. Legal AF MTN. I sit and I curate at the intersection of law and politics. I bring you the content that you've been looking forward to, and you can only find right here on Legal AF MTN, where I'll be doing exclusive content, new shows like Unprecedented, where every week we're going to talk about the United States Supreme Court and what happened there now. From ethics scandals to new cases selected to oral arguments and decisions, all through the term, first Monday in October until the end of July. Unprecedented on Legal AF MTN. So until my next hot take, Legal AF podcast here on MeidasTouch Network, or all the content on Legal AF MTN, free subscribe. This is Michael Popok, and I'm reporting. In collaboration with the MeidasTouch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.